this lecture, let's talk about employment law and just touch on immigration law as well. For purposes of this, instead of being an employee, please put your employer hat on. You're going to be a manager and or owner of a company as an MBA graduate, so try to view this as the employer and the responsibilities you have that way. Now, what rights do employees have to continued employment? Well, most states, it's what's called an employment at will doctrine, and an employee can be terminated for almost any reason that doesn't have to do with, race, ethnicity, age, etc., which is covered in another lecture. So almost every state is presumptively, we're just giving you the general rule, and then the exceptions, which mostly swallow the rule, is that you can fire an employee when you want to. Now, there are some exceptions. When can you not just fire an employee when you think it's appropriate or when you want to? Well, when there's a contract. Person has a contract of employment. You tell me you're going to hire me for 1 full year. Unless you have a cause, I breach the employment contract. I do something stupid at work. You got to keep me employed for a year. That's an express contract. There also can be an implied contract. Sometimes if you have a company policy, company handbook, a boss has said, I need somebody around here, for 2 years or da-da-da-da, then that's might be considered an implied contract. It wasn't really expressed and written, but it was implied by something your employer said or did. What's the second reason you might not be able to terminate me as an employee? Well, if you have to have good faith and fair dealings. So many states, a minority of states, I should say, of the 50, won't let you just terminate me for anything. There has to be some sort of good faith benefit. You're reducing the workforce. I wasn't a good fit for the job. I didn't sell as much as you wanted, something like that. So there has to be a good faith in there. And obviously, you can't sue me for, sometimes an employee can sue you for breach of employment contract, wrongful discharge, etc. What's a third reason you might not be able to terminate me at will, that is whenever you want? Public policy reasons. For example, if I was a whistleblower, I find out that you as the employer are doing something against the law and I reported it, you can't fire me for that. If I had a legitimate work comp injury, I hurt my hand on the job, you can't fire me for taking work comp benefits. I've got to go do jury duty. I'm in the military and I have to leave for 3 months. These are public policy reasons that the law protects me as an employee and doesn't permit you to terminate me. Obviously within public policy, which we'll cover at another time, is race and the ethnicity, religion, etc. That is another reason you can't just fire me at will. Now, let's talk about wages and labor standards, etc. There are a number of federal laws that talk about that protect U.S. workers' rights. One is minimum wage and overtime pay. General rule, you have to be paid a minimum wage. And if you do overtime, more than 40 hours a week, you have to be paid 1.5 times your minimum wage. I'll say that again. You have to be paid a minimum wage. Once you go over 40 hours a week, generally you have to be paid 1.5 times. That's if you're an hourly employee. We'll touch on that later. Also, child labor is prohibited. Now, let's look at a map of this. I'm recording this in 2021. You may be watching this years later, but these numbers are going to change, but the concepts will stay the same. There is a federal minimum that every state must meet, except you'll see 2 or 3 exceptions. We won't get in here since we're not in those states, but they usually have to do with like server jobs, etc. But let's just say, for purposes of this, that the general rule is you have to hit the federal. At the time we're taping this or recording this, that's $7.25 an hour. But you'll see many other states pay above that. This map shows California, for example, at 13. It's probably risen since then. Massachusetts at 12.75. So the state can add a higher minimum wage than the Fed set. The Fed is a baseline. Now, if I'm working for you and you own a restaurant, you don't have to pay me minimum wage if I get $2.13. Again, these numbers are going to change over the years, but roughly $2 an hour pay, and then I get up to the minimum wage, $7.25 an hour on the average, in tips. Okay, so then effectively as an employer, you're able to say, well, you are getting paid a minimum wage. I'm paying you this dollar, and then I'm letting you keep this $2. I'm letting you keep the wages and it better, or the tips, and it sure as heck better get you at minimum wage or they're in violation. Okay, if not, they have to make up the difference. You, the employer. Here's the old, if you work 40 hours a week, anything that over, you get paid 1.5 times hourly. Okay, let's say that again. You work 40 hours a week at your agreed rate. You told me you'd pay me 20 bucks an hour. Okay, if I work 50 hours a week, then that 10 hours, you're going to have to pay me $30 an hour, 1.5 times the $20 an hour rate. Now, that's a general hourly rule. Let's look for some exceptions. When would you not have to pay overtime as an employer? You cheap MBA students, you. If I'm an executive, there's an exception if I'm an executive. I'm hourly, if you will. I'm not hourly, I'm a salary. So I make at least $6.84 a week. Here you can see some of these other tests. I can hire, fire. I'm really managerial. Then you don't have to pay me overtime. Another reason is administrative. Okay. Again, you see the minimum pay I have to receive. I do non-manual work assisting management. Okay. That's administrative exception. Another reason you might not have to pay overtime to me is if I'm a professional. You hire me, but I'm a doctor, I'm a lawyer, I'm an accountant, etc. I'm a scientist. You may be able to say, no, this individual is a professional, so they don't fit within the hourly pay requirements. Also a creative professional. If I'm a graphic designer, for example, you can pay me salary instead of hourly. It's interesting, computer types. I don't know why they did this, but IT people, for example, same thing. They could be paid salary and you don't have to pay overtime as long as you meet these tests on these various pages. I'm going through quickly, but I'll expect you to go back and read them. Outside sales. I'm not inside your company just taking orders, but I'm out trying to sell your product. I'm selling cars. I'm doing whatever. You don't have to pay me hourly per se or overtime. I'm an outside salesman, so I'm an exception to that rule. Highly compensated, the most enviable of positions. If I make X amount, a year ago it was $107,000 a year. I'm sure it's gone up since then. It'll go up in future years. But if you're making over $100,000 a year, then you can be an exception to where you can require me to work more than 40 hours a week and probably don't have to pay me overtime. Also, it's rather antiquated, but the laws basically divide white-collar and blue-collar workers, and they generally don't allow you, the employer, to pay blue-collar workers, let's say manufacturing or something like that. They often, in almost every instance, don't allow you to pay a salary. You must pay hourly. Okay, so that's known as a blue-collar rule. Police, fire, I'll let you read through police, firefighters, etc. Also, union members, if there's collective bargaining agreement, the collective bargaining agreement, your union agreement with the employer, will determine the pay rate. All right, let's say that you're now going to lay off a bunch of people, okay? Well, if you have more than 100 full-time employees and you're laying off, a significant number of them, then you have to give them 60 days notice before a mass layoff. this gives them the opportunity to go look for another job. I mean, a lot of employers don't want to give anybody advance notice, but if you're, basically getting rid of almost all the workforce, you have to give them the opportunity to look for another job, essentially. FMLA, Family Medical Leave Act. I'd like you to read the specifics of this, but essentially federal law provides not as generous in the U.S. as it is in many countries in Europe, for example, but more generous than some other countries, is that if there's a serious health condition that employees can take up to 12 weeks unpaid time, and you can't fire them for being off. You can't demote them. You can't do a bunch of negative steps towards me as an employee when I've taken it off. What are these type of serious health conditions? Let me just read a few. There's 6 categories. I'm in the hospital. I'm incapacitated. I have a baby, et cetera, et cetera. These are the type of things that are qualify for me to take leave under the FMLA. You'll see who is subject to that. Either your public employer, which means government, or your private company, but you have over 50 employees, okay, etc. Military service. So anyway, I'm going to let you read through the various conditions of that. Let's talk about worker safety. OSHA. OSHA says, essentially, I want you to read through this, but you, employer, you have the requirement to provide a safe working conditions for your employees. You can be fined if you do not. You have to have a record keeping, injuries, specific dangerous conditions. You have a duty to remedy dangerous conditions. There's a lot of laws within here. You have to inform workers. You have to give training to workers. You have to give them safety equipment, do tests in the workplace if it's appropriate, air sampling quality, etc. So basically OSHA is protecting workers' safety, and different OSHA regulations will apply based on the type of employer you are. For example, somebody that's at a petrochemical plant may have different types of specific guidelines they need to follow, as opposed to somebody that's working in the mall, for example. You're probably not going to have to conduct air chemical safety analysis if I'm working in Macy's, but you will if you're in a chemical plant to make sure I'm safe. So once you get into OSHA, you'll have to look at the various requirements very specific to you, your type of industry as an employer. Work comp laws, bottom line, if you have employees, and we've already talked previously about if somebody is employee versus an independent contractor. Don't try to call somebody an independent contractor if they really are an employee and you control them. But under state laws, you have to carry workers' compensation coverage for them. And basically that means if they have on-the-job injury that's accidental, almost regardless of cause, you paid for insurance to cover them, okay? It occurred on the job, and it's in the course of employment, regardless of fault. Social Security, I think most of you are familiar with that from a personal standpoint. I'll let you go through the tax contributions you have to do, the retirement, etc. Income security, let's talk about the types of things that protect employees. Unemployment insurance, you also have to pay unemployment insurance as an employer, or if you're self-employed, you'll have to pay various taxes to cover these things. This basically protects workers that are terminated, not for cause or that quit, but are terminated, a reduction in force, or you just couldn't have as many employees or whatever, you wanted to terminate somebody, but it wasn't because they did something for cause. Well, that worker has a right to get unemployment benefits. Now, a lot of employers don't want to have the state pay unemployment benefits because then the employer's unemployment insurance premiums go up. And so some employers fight them from time to time. But if you have somebody that quits and wasn't terminated, for example, there are various scenarios in which, or he was fired for cause, there's various scenarios in which the person can't seek unemployment. COBRA, this is just a concept that basically an employee that leaves employment has a right out of their own pocket to continue their insurance coverage, and you have to give them notice of that right, okay? That falls on you as the company. Say, hey, you can continue to pay for insurance out of your own pocket and be under our plan for a certain amount of time. HIPAA. Now, this usually, years ago, this really only applied to doctors' offices and hospitals and et cetera, insurance companies. But now it's much stronger to you because if you're in HR, for example, at your company, you're a manager. If you have employee health information, one of your employees has mental health issues, there are restrictions against you using that or disclosing it without their authorization. So be very careful about that. That's a very serious thing. Now, I'm going to do a little footnote here and talk about the use of employee data. And if you're in Europe, this is now a very important thing. Let's watch a quick YouTube on what you can and can't do if you happen to have employees in Europe in your company, or if your affiliate has employees, or if you have a European customers, European affiliate, European-based employees, like your distributors, but they're employees. You have to be careful with what you can and can't do with their data.
Do you ever feel like you're being watched? You are. The browser you're using is allowing your behavior to be exploited and...
The General Data Protection Regulation, or GDPR as you've likely heard it called. It goes into effect on May 25th, and it could affect you, no matter where you are or where you live. How? Let's answer some questions. So, what is GDPR? It tightens Europe's already strict laws about what companies can do with people's data. It gives you more control over how your data is collected and used, and forces companies to justify everything that they do with it. While GDPR is European Union legislation, it has a huge effect on businesses outside the EU, including the US. Why was GDPR introduced? Because the old laws were written before smartphones started collecting massive amounts of sensitive information for companies like Google and Facebook. GDPR gives organizations guidelines on what they can and can't do with personal data. It also makes them give users more clarity over the kind of data being used and how companies will use it. What is considered personal data under GDPR? Any data that can identify you. That's your name, phone number, or username, but the law also includes things like your IP address or location data. Even tighter rules apply for sensitive information such as sexual orientation, health data, and political opinions. How will it affect you? One way is that you will often have to opt in to letting a company use your data. This means fewer pre-ticked boxes, and firms are compelled to use clear and simple language. Do people have the right to be forgotten? Yes, people can request to have their data deleted. Personal data also needs to be transferable via a common file type. However, the right to be forgotten is not absolute, and certain conditions apply. Why is GDPR a concern for non-EU countries? Because many businesses collect or use EU residents' data. They also use companies based in the EU for services and processing data. What happens if a firm doesn't comply with GDPR? The penalty could be up to 20 million euros or 4% of annual turnover, whichever is larger.
Okay, so I presented the GDPR in the context of employees, but like I said, it could be customers, it could be representatives, etc. Have you noticed how you get cookie notices and privacy notices in various websites now? That sure as heck isn't because out of the goodness of their heart, the websites, it's because it is required by law, okay? Now, how about employee privacy rights? Can we monitor them? Can we read their emails? Can we, have video of them? Well, let's look at some various specifics because this is kind of a flexible area of the law that moves over time. Various states have different laws of privacy protection. They could say it's an invasion of privacy. Some state and federal statutes will monitor how much you can do. However, employers generally, as long as they put employees on notice, generally have the ability to monitor employees, that have video of them in reasonable areas. You don't put it in the restroom or maybe not the break room, but to have that surveillance if they're notified and if you use it for proper purposes. Email, for example, if they're using private email, you probably don't have a right unless they're using work computers to look at them. Even then, I'd be pretty darn careful if it just happens to go over your server. But you should have a policy in place, and all the employees should know anything you write about the company on our computers or on our servers, we, the employer, have the right. So make sure employees know what you're doing and never use it for an improper purpose. That's a general overview, if you will. Drug testing. How about this? Fourth Amendment. You might have heard that. Unreasonable search and seizure, unreasonable testing doesn't apply to the employment context. So let's just talk about Oklahoma law in general. I can require you to take a drug test if you're applying for employment, or once you're employed, I can make you take a drug test if you had an accident. We're doing random drug testing to everybody. I'm not targeting you as an employee. We just do it randomly. So don't try to target one person. It has to be random if you're claiming the reason you're testing is random. Fitness for duty exam in some careers. Follow-up rehabilitation. Somebody's come back after, you've had agreed leave of absence and they had to go through counseling or this or that. As a follow-up for rehabilitation, you could do it. You can also test for cause, like somebody's in manufacturing and they really, either they look just falling over, stumbling, for example, or they injured themselves, and you have to see, look, were they inebriated or were they so drug-induced they couldn't do their job, and we have safety concerns here. Those are times when you can require the employee to be tested. I'm going to let you do most of the immigration law, but basically, let me give you some highlights or lowlights depending on your aspect. In other words, things you must do. As a U.S. employer, you have an obligation to ensure that your employees, it is lawful for them to work in the U.S. And if you don't, there could be criminal liability on your company, and definitely fines or potential criminal liability. So that's why when you apply for a job, you'll often, give your ID. You'll say, yes, I'm a U.S. citizen or I have a right to work, or et cetera, et cetera. You have to give that information. But as an employer, you're responsible for ensuring that is correct. If you don't, here's some fines. And if it's a pattern in practice, you've done it multiple times, it can be a criminal problem. All right, I'm going to let you go through immigration, but essentially, let's cut all of the visa issues into two. One is work-related, coming into the U.S., and another is non-work-related. So you will be interested in the work-related. So like an H-1B, for example, you might be able to get somebody in from outside the U.S. to work for you because they're in a specialty occupation, and you can see the things that you have to do here when you read it. You might do an L visa, which means, hey, I've got a manager over here that I want to bring over here and train for a year. So there are various categories of visa that are related to employment. That doesn't mean someone is immigrating That means they're here for a limited time and for a employment-related purpose. Over here, we have non-employment related. There might be students coming. There might be people applying to be permanent residents in the U.S., having nothing to do with employment. So in your mind, keep in mind the important thing, I guess, is there are employment-related visa/immigration issues. There are categories of employment, and you have to choose the right category based on who you want to come in to work for your company. I'll let you read through those, and the text does a fairly good job of explaining those. Let's see. We also have federal labor laws that protect unions, and essentially on this particular slide, you can see on page 55, this is sort of outlines what a company cannot do when it comes to unions. Okay, so I want you to read through there. Like if they're trying to, if you're not a union shop, let's say, then, and your employees are talking about having a union, you can't interfere with that. That's a legal right. Amazon, for example, as when I'm filming this, various facilities, people are talking about forming a union, and Amazon has to be careful not to interfere too much in, stopping people from joining a union. I mean, they can express their opinion, but they can't coerce people or prohibit them from joining a union. That's against federal labor laws. See some of the other things, discrimination hiring. I can't hire somebody or not hire somebody based on their union affiliation, or I can't promote somebody because he's non-union. But you can just go down through and see these things that are prohibited under labor law, federal labor law. And so that really has to do with unions. That might be it for this very quick lecture. Most of this goes with labor law down here, which we're not going to cover. I do want to show you pretty quickly, and you'll see this in the materials that you can access. There are various laws that show what you must post in the workplace. In other words, what you must put the employees on notice of. It has to be either digitally for them or placed in a prominent position in a break room, somewhere where they will see it. They have to know that. Here's a poster, for example. Well, let's go through them. This one puts employees on notice that you can't have discrimination, race, color, religion, national origin, sex. I'm sure the current poster also says, well, it does say gender. Let's see. Yeah, sexual orientation, stuff like that. So this is going to be updated probably, but you get the gist of it, that the employees are on notice. They can't be discriminated against based on this. For example, religion. I can't discriminate against you if, you're this religion versus such and such religion. Here's another one, law, equal opportunity. And it's another great thing. And this is an even better explanation to employees that you post and say, if you have disability, they can't retaliate against you. If you're of a certain age, you can't be discriminated against, etc. So, and if the employer does discriminate against you, call this 1-800 number and you can report them. FMLA, you should post this to show your employees their rights under the Medical Leave Act, okay, what they can and can't do so they know. Employee rights, Oklahoma happens to have a polygraph poster that, when you can require an employee to take a polygraph test. Let's say if you suspect they've stolen something. I will add a personal note. Polygraphs have been so disproved as to their efficacy and reliability, but some employers might use those in if there's employee theft or things like that. If you do, you should have this poster up. Here's another one, Minimum Wage Act. Get this one up so employees know the minimum amount to which they're entitled, and then you'll see the some of the definitions that we put up. Here's a notice to workers. Unemployment insurance, we talked about that. Here's the Oklahoma form for that you should have up somewhere. Here's the minimum wage poster you should have up somewhere to know. And again, minimum wage, I'm recording this in 2021. It didn't change from 2009. So whether you're for or against this, that you make sure that these posters are current. And there are a lot of resources. You can literally just look online and Google and find what the current poster is and print it out. OSHA, safe workplace. Also work comp, if they have an injury, what their rights are. So this is a form for that. And finally, for people in the armed services, they have rights as far as leave and et cetera. Can't be discriminated against because they had to go to National Guard on the weekend. It couldn't work. They were on active duty or something. So this poster also is wise to have up to inform any of your employees. Okay, very quick lecture today, but please, I implore you to go ahead and read through these materials and access the textbook if they're not clear to you, any of the concepts. Thank you.